Good afternoon. The 14B District Court is now back in session. The court will call the case of the state of Michigan versus Darian Randolph, case number 23S00446.
APA Rich McDuffie for the people.
Good afternoon, Your Honor. Uwe Daus appearing with and on behalf of Darian Randolph, who is joining us from a different location. I don't know if he's there or not.
He is here. Please unmute, Mr. Randolph, and state your name.
My name is Darian Randolph.
Thank you.
Thank you.
First of all, I want to apologize to everyone. There was a court case at the service center that did not make it to my docket, which apparently I didn't hear about until sometime after 2. So I had to go handle that, and that's why I'm just coming back to this. All right, having said that, we're here today. This is a competency hearing, it's my understanding, and Mr. Daus has requested that we hold a hearing. Are we still in the same space that we were in before?
Yes, we are. And Judge, no apology necessary whatsoever. Thank you.
Thank you.
Is Mr. Parker from the center present?
Yes, Mr. Graham Parker is present.
Very good. Yes, then we are in the same position. I have a roadmap, what I'm looking to get out of Mr. Parker relative to his opinion, and then have some summation at the end. I should note that a couple of weeks before today, Mr. Parker and I had a Zoom conference of our own at his suggestion to sort out what our concerns were. So I have spoken to him before, and I will essentially follow the roadmap of that conversation here today.
All right, thank you. Ms. McDuffie, is there anything you want to say before we begin? Or I believe, although it's a competency hearing that's requested by Mr. Daus, I believe you question first and then Mr. Daus gets the opportunity to question afterwards, but I don't mind if we go in a different order.
Thank you, Your Honor. I would have to ask for that to be the case for today's hearing, because my understanding is that once we received the competency report, which did find Mr. Randolph competent to stand trial, Mr. Daus is essentially challenging that report. And with me not having, I have some gist of what he may be wanting to address, but he is really the one who would be able to ask the appropriate questions to get at the answers he's looking for based on what it is he's contesting in that report. So given that, I would ask, though, that before we begin, if Mr. Daus could just give us a quick sort of summary in a line or two about what some of the basic issues are, so that I'll be able to listen attentively with that context provided.
Yes, and thank you. And Ms. McDuffie, did you mean for me to go first?
Yes.
That I'm good with that. That's what I thought we were going to do.
Okay.
Yeah. The roadmap is this. We have an opinion from Mr. Parker. It's 5 pages long. There is in his opinion something what I perceive as holes, pieces of information that are missing. And I do believe they matter. And if they were provided and considered, perhaps that would change the opinion or ultimately the court's finding as to Mr. Randolph's competency. So I'm looking to fill in holes with information that I believe is missing from Mr. Parker's opinion.
Thank you. You may proceed.
Thank you. Can Mr. Parker be brought on? I do not see him.
He's here. Mr. Graham Parker, could you please unmute your device? Raise your right hand to be sworn, sir. Do you swear or affirm that the testimony you're about to provide will be the whole truth and nothing but the truth?
Yes, I do.
Thank you. You may
Thank
proceed.
you. Thank you, Judge. Good afternoon, Mr. Parker. Thank you for being here. Briefly, I understand you work for the Department of Health and Human Services.
Yes, that's correct. I'm employed by the state of Michigan and work at the Center for Forensic Psychiatry.
Thank you. And about your credentials, you are a licensed master social worker?
Correct.
You are also a certified forensic examiner?
Correct.
Who certifies you as a forensic examiner? Is it the state of Michigan?
Yeah, so there's a set, there's a standard where we first are supervised doing 10 evaluations. So those are supervised by other people who have been certified. And then once we've reached 10 evaluations, we then do a mock trial. And at that point, the director certifies that we are forensic examiners.
That's the director of the Department of Health and Human Services?
No, that's the Director of Training and Research here at the CFP.
Very good, thank you. Since when have you been certified as a forensic examiner?
I got my certification September 1st, 2023.
23. Thank you. I understand you do both criminal responsibility and competency evaluations.
No, so social workers only do competency evaluations.
Oh, thank you. I did not know that. Thank you for the clarification. How many competency evaluations have you done?
So I've done a mixture. So I've done 56 evaluations on the evaluation unit. And then I've done 14 restoration evals on the treatment service side. So those 14 are individuals who've already been adjudicated incompetent, come here for restoration treatment, and then I have to do a competency evaluation before they can be returned to the court.
Okay.
So in total, there's 70.
70. Okay, let me clarify something. Of the type of evaluation you did with Mr. Randolph, of that type, how many have you done?
56.
56. Thank you. Good. About Mr. Randolph's evaluation, I understand you saw him on February 6th at the CFP.
Correct.
And you provided an opinion dated February 13.
Correct.
And do you have access to that opinion? Can you review it where you are?
Yes, I have a copy.
Very good. Thank you. I will go to particular sections, paragraphs of that opinion, and then stop there and ask about that particular section. The very first one I want to ask you about is on page 2, under the heading Relevant Historical Information. The third paragraph reads that regarding psychiatric history, Mr. Randolph reported that he has been hospitalized psychiatrically on 3 occasions. Do you see that in your opinion?
Yes.
Okay. There is no further reference in your opinion as to when, where, for how long, or what for Mr. Randolph was psychiatrically hospitalized. Do you have that information? When and where and for how long he was hospitalized?
So I received some records provided, I think, by either you or your office that I briefly reviewed after I had met with Mr. Randolph. So I have that information.
Okay, thank you. I think that's the answer to the question I was asking. Thank you. So do you know when was Mr. Randolph's most recent hospitalization?
Off the top of my head, I do not.
But that information is somewhere within your source of information?
Correct.
Okay, it's not mentioned in the opinion. Is there a reason for not including this information in your opinion?
Yeah, so in terms of competency, the question that I'm attempting to answer when I see a defendant is their competency at that point in time. So as they're sitting in front of me, are they capable of understanding the nature and object of the proceedings against them? And can they assist rationally in their defense? So those records wouldn't have helped me answer that question in that moment.
Very good. And thank you. I take your answer as you do provide it, and I will go on to the next question. Did you then or did you not use any of Mr. Randolph's hospitalization information informing your opinion?
No.
You did not. Okay, thank you. Then let's go on in the written opinion of yours to the next item that I'm looking to ask about. It is on the top of page 3. No, I'm sorry. I'm getting ahead of myself. Still in the same section that my earlier reference was for. It reads that Mr. Randolph is being treated at Washington County Community Mental Health and reports that he's taking praloxine, an antipsychotic. There's no mention of, in your opinion, of why he is a CMH patient or for what condition he is taking this antipsychotic. Do you know that information?
So at the time of the evaluation, I was not aware of a diagnosis. Mr. Randolph did not provide a diagnosis. I later became aware of a diagnosis, but that was when you and I met a few weeks ago.
Thank you. So at the time of the evaluation, you did not have that information.
Correct.
Thank you. That already answers my next question. I would say then you did form your opinion without considering that information. Is that fair?
Sure, I was aware that, in those records that I had, that there was mention of him having psychosis, which is a symptom, but not a diagnosis.
Understood. Thank you. I take your answers to mean that at the time of the evaluation, you did not know that Mr. Randolph had a diagnosis of schizophrenia. Is that correct?
That's correct.
Okay. Would knowledge of Mr. Randolph having that diagnosis of schizophrenia, would that affect your opinion?
Based on his presentation at the time of the evaluation, it wouldn't have changed my opinion.
Thank you. If I go quiet, it is because I'm taking a note of your response. Thank you. Good. Let's move on to the next item in your opinion that I have a question about. It is now on page 3, the top paragraph. There is mention, sort of like the 5th line down, Mr. Randolph expressed various paranoid delusions throughout the interview. Do you see that line?
Yes.
But where are you at? I'm sorry. Page 3?
Yeah, page 3, top paragraph. I believe it's the 5th line down.
Okay,
Mr. Randolph.
I see it.
Thank you. Thank you. And a little later in the same paragraph, there's somewhat of a repeat that he was endorsing various paranoid delusions. That's the section that I'm at and have questions about. Mr. Parker, did you note the number and frequency of what paranoid delusions Mr. Randolph expressed? Just the number and frequency?
I did not note the number. I think from memory, it was approximately 2 to 3.
2 to 3 total.
Total, yes.
Thank you. That answers my next question. About of those 2 to 3 total, I take it they were each different from the other?
Yes, yeah.
Okay. And do you recall, or do you have any notes of what particular statements Mr. Randolph made?
So, yeah, so he reported a belief that his mom was involved in these hospitalizations that you'd mentioned, which appeared paranoid in nature. The sort of idea that his mom was intentionally like out to get him there, and then seeking hospitalization. He referenced a belief that his mom knew Your Honor and had sort of an ear, or her ear, and by her ear, I mean she was able to speak with Your Honor. And then the last one is that Mr. Randolph made mention of this belief that when I had asked him if he understood what attorney-client privilege is, he mentioned a belief that you, Mr. Doss, were in communication with another rapper in Ypsilanti and sharing information about the case with this person.
Okay, thank you. Are you reciting these items from memory, or do you have any notes of those?
Just from memory.
That's impressive. Thank you. You labeled these statements as paranoid delusions. How difficult was it for you to make that determination? Did you have to think on whether this is paranoid or delusional, or was it pretty clear cut on your end?
I mean, so I've been assessing patients with mental illness for a significant number of years. So, I mean, it sounded far-fetched pretty much immediately.
sounded far-fetched and good. Thank you. Enough about that section, but let's move on to the next. I think it's already now on the last page of your opinion, the page 5, under the heading opinion regarding competence to stand trial. You do conclude first sentence that Mr. Randolph does not have a current mental condition that renders him, I paraphrase, that renders him incompetent. Is that correct?
Correct.
That is your opinion. Do you happen to have on hand a definition of schizophrenia?
I don't offhand know.
Okay. We may be able to source that from someplace else, but thank you. Are you familiar with the diagnosis though of schizophrenia?
Yeah.
Yeah. Question: is schizophrenia a mental illness that may at times render someone incompetent?
So yes, it's a mental illness, but the question I'm attempting to answer when I meet with a defendant is not whether they have a mental illness. If they do by chance have a mental illness, the question I'm trying to answer is whether or not, due to that mental illness, their mental condition at present time renders them incapable of assisting in their own defense in a rational manner or understanding the nature and object of the proceedings against them. That could be the case. It's not always the case that somebody with schizophrenia necessarily is incompetent.
Okay, then I understand your answer to be that you're looking to determine mental health condition in the moment of evaluation, but that wasn't my question. My question was, is schizophrenia a condition that could render someone incompetent?
It's possible, yes.
Possible, okay. A number of times today, and even in your opinion, I think you make the point that your opinion is based on the evaluation at the time of making Mr. Randolph's evaluation. Is that correct?
Correct.
Yeah. Do you know whether Mr. Randolph is competent at other times, a week before, a week after, at other times than the evaluation? Do you know whether he is?
I couldn't answer that question. I can only answer, about the time that I saw him.
Okay. And do you also, you do not attempt, you don't endeavor to speak to his competency at other times. Am I correct?
Correct.
Okay, thank you. I think I'm getting towards the end of my questions. If Mr. Randolph is delusional, or you found him to be delusional, even in the 1 hour that he was with you on February 6th, how do we know that he adequately understands implications of his choices and decisions that he makes with regard to this case?
So in that time that I met with Mr. Randolph, he understood what his charges were. He understood the associated maximum sentence for each charge. He understood what plea options he has. He understood what a plea deal is. He understood and was able to effectively communicate his desires for how he wants to proceed with this case, despite voicing some what I would call delusional beliefs, paranoid delusions. He was able to compartmentalize those beliefs and say that, he wanted to just, work with you, Mr. Dawes, in an effective manner in order to resolve his case. Now, typically, if somebody is experiencing a mental condition or has a mental illness like schizophrenia, like you mentioned earlier, that belief about you sharing information, that delusional belief, in previous evaluations, such defendants would answer, or they would say, I'm not going to work with my attorney. I refuse to work with him. He's sharing information about me. I want to either represent myself or fire him. That was not the case with Mr. Randolph. He was agreeable to working together with his attorney in a way that helped him to quickly resolve this case.
Okay. Let me think about that for a moment. Okay, I hear what you're saying. One last item about your opinion. At the very last paragraph on page 5, there is a reference to the words "if he so chooses." You found Mr. Randolph not precluded from understanding the nature and object of the proceedings against him or of assisting in his defense in a rational manner if he so chooses. Those words, if he so chooses, they throw me. I don't understand what these words are doing there. It sounds as if you ascribe Mr. Randolph some agency in his delusions. Is that what you're doing? Or?
No, so whether he's delusional or not is sort of, for me, kind of a moot point if he's able to successfully put those beliefs to the side. He might still believe in them, but understand that it's in his best interest to not allow them to dictate how he proceeds with this case.
I thank you. That is something I'm not sure I understood before. It is his ability to set aside his delusions that make you feel he's competent.
Sure, so he can still believe them.
Mm-hmm.
He might still believe them to be true. However, he's able to say, in order to quickly resolve this case, I need to just move on from that or set it to the side and deal with my case in a way that is best for me.
All right. All right. Thank you. I believe I'm through with what I intended to ask. Thank you, Mr. Parker.
Thank you. Any questions from you?
Just a couple, Your Honor. And thank you again, Mr. Parker, for being here today. So let me ask you, I think that you laid it out pretty well in the beginning in terms of what a competency evaluation is and is not, but I want to ensure that I'm really clear on that point. Have you, in the number of other evaluations that you've conducted, have you, do you have a rough count of how often you've evaluated individuals with a known diagnosis of mental illness?
I would put it, this is an approximation and a guess. We don't track that information. I would say it's the overwhelming majority of the time that the reason that a defendant gets referred to us is because the attorney will state they have a history of mental health treatment or taking medications while in jail or whatever. So I don't know that I could put a number on it, but I would say it's the majority of the time.
Okay. And I was asking specifically about a known diagnosis, which would be at the point where you're conducting the evaluation that you receive information or confirmation of that person's diagnosis. Do you feel like that's the majority of the time versus the suspicion that something may be going on?
Okay, I would say it's far less frequent. I say the suspicion is most of the time. Actually getting a diagnosis from an attorney is very infrequent.
Okay. And just to be clear, the purpose of this evaluation is not to diagnose anyone, correct?
Correct.
Okay. So when it comes to this report, this is kind of a weird way to ask this. What is your general sense of where this report might rank, for lack of a better term, with the behavior that you've seen in your other evaluations? So in other words, is this something that stood out to you? Did some of these delusions concern you? Is this an example of something that's pretty dramatic, or do you have any sort of opinions about that?
Yeah, I would say that it wasn't an evaluation that necessarily stood out to me as being exceptionally bizarre or something, it wasn't something that I immediately felt like I needed to consult with other staff about. For me personally, I formed my opinion pretty quickly after meeting with Mr. Randolph. So it wasn't incredibly bizarre. I don't know if that adequately answers your question.
It does. It does. And next, I'll ask you: have you seen or have you evaluated other defendants who have exhibited more concerning, I guess, bizarre behavior, and still found them to be competent to stand trial?
Yes.
Okay, go ahead.
So I've had people who, are responding to internal stimuli. And what I mean by that is they're hearing voices and responding in real time to them, and may have some distrust of their own attorney. In the case I'm thinking of, did have distrust of his attorney, but was able to set that to the side. There was and understood, court, the nature and object of the proceedings. He understood how to rationally assist, and I called him competent as well, or gave the opinion that he was competent.
Thank you. And you've already sort of touched on this, I think, a couple of times, but in the report, it details in the section called psycholegal abilities related to adjudicative competence. You go on in detail. That section begins on the very bottom of page, I think, 3, and picks up on page 4. Just making sure everybody has an opportunity to turn to that. So in all of these paragraphs here, where you lay out Mr. Randolph's apparently very clear understanding of what this legal process is, what sort of decisions are made, proper and improper courtroom behavior, capacity to effectively communicate with you, defense strategies, legal options, what his preferences may have been to even resolve this case. At the end of all of that, did you say earlier that you did not have the information regarding Mr. Randolph's diagnosis of schizophrenia prior to that?
Yeah, so the documents I had at that time indicated that he had psychosis, which isn't a diagnosis. It's not a diagnosis, it's a symptom of a diagnosis. And then I later became aware that he has a diagnosis of schizophrenia.
Okay. And are you of the opinion right now, today, that had you had that information, that specific diagnosis, that it would have in any way changed your findings here?
It would not have changed my opinion.
And the information that you lacked in terms of some of the detail that Mr. Doss mentioned earlier, which was that diagnosis itself, the medications he was on, you were working from, is it fair to say, all the information that you were provided by him prior to the evaluation, correct?
Correct.
Okay. So there's no information that you had in your possession that you chose not to look at or consider?
Correct.
Okay. Your Honor, I believe that that is all of the questions I have.
All right, thank you. Anything further, Mr. Dawes?
No questions of Mr. Parker, just summary to you who ultimately has to make a decision here.
All right. All right, thank you, Mr. Parker. This witness may be excused, correct?
Your
Yes.
Honor, I'm sorry. I did think of one last thing. Could I just do that one last question?
Yes.
Mr. Parker, you explained, I think at the very beginning, that this was an exam or an evaluation for competency and not criminal responsibility. Could you just briefly advise us on what the difference is between those two?
I'm fully aware of what the differences are between the two. So.
Oh, I know that the court is, but I just wanted the record to reflect that, because the questioning that he received was, I think it sounded like it was a reflection of going back in time, which I believe, if I'm not mistaken, is what criminal responsibility does versus competency. So I just wanted the record to kind of contain that information too. But if the court doesn't find it necessary, we can move on.
I don't find it necessary. If you want to make the record, you can go ahead.
Okay.
Oh, should I answer?
Yes.
Mr. Parker, did I sum it up correctly? If so, we won't need to go any further.
Yeah, that's a good summary.
Okay, thank you, sir. Nothing further.
All right, thank you. All right, you may be excused, Mr. Parker. Thank you so much for showing today and testifying here in court today. We appreciate it.
You're welcome. Thank you.
Thank you.
Thank you from our side as well.
Thanks.
All right, Mr. Dowse, do you have any further witnesses, I guess?
I do not know. I only have a summary of what I think and believe.
All right, you may proceed.
Thank you. First, I have an observation that I didn't think to make until Ms. McDuffie was asking questions of Mr. Parker. I don't believe that Mr. Randolph's competency is to be determined in comparison to that of others or by statistics. I think a number of questions of Mr. Parker were of that nature. I don't think that's right. I want to let the court know where we are coming from. One, I don't want to be seen as advocating for Mr. Randolph to be incompetent. I'd much rather that he wasn't. But the crux on our end is that we as his counsel do not know at any time whether he is or isn't competent or what is his state of mind. Let me describe where I'm coming from. We have represented Mr. Randolph once before, 5-6 years ago. And then we've represented him again since September 2023 on this case. He is markedly different now since September that we've represented him than he had been 5-6 years ago, and he is worse. We have numerous encounters and communications with him, both in person, face-to-face, communications by phone, by email, by text, and they are very varied in nature. On the one end, there is occasions when he is coherent and appearing sound to us. We couldn't tell in those moments that there's anything off or wrong with him, or I don't want to say wrong, but different. Those encounters are the exception that we have with him. On the very other end, we have had numerous encounters and communications with him where he does seem to be far out of his mind and out of reality, where he is nonsensical, where we get nothing but paranoia and delusional statements, basically one after the other. And I can observe that if he is in one state or the other, it doesn't change throughout our, say, hour-long or 2-hour-long meeting. He is either one way or he is the other way. That to us is very concerning because out of that, we simply don't know what his mind is up to at any given time. I want to note that Mr. Parker's opinion is, I'm not fussing with Mr. Parker's opinion that he found Mr. Randolph to be competent in the hour of their evaluation. I'm not really taking issue with that. I do want to note that it was done without knowledge of what I believe is a major mental illness of schizophrenia, one that is recent, and one that apparently it was not present in past years. Even Mr. Randolph's prior to hospitalizations, on those, okay, I do have the records, I have reviewed them. He was basically flagged and monitored for schizophrenia, basically to rule it out, and he did not receive the diagnosis. The diagnosis is a very recent one. Incidentally, it came about after we had made the referral for his competency evaluation in December. And Mr. Parker acknowledged that the condition is one that someone who is afflicted with it may render that person incompetent at times. Out of this, it's our view that we simply do not know today, next week, or last week, whether Mr. Randolph was competent. Not so much the first prong of the standard of understanding the nature of the proceedings and the nature of the charges. Our concern is with the second prong of assisting in his defense in a rational manner, because more often than not, he does not seem rational with us. I'm sorry, I have two more observations that concern me that came out of Mr. Parker's testimony here today. It was about the paranoid statements, delusional statements that Mr. Randolph made to Mr. Parker at the time of his evaluation. There was the one that apparently he believes his mother is in your ear, your judge's ear about the case.
I heard that. That's interesting.
Interesting, and I find it concerning because it does speak not to Mr. Randolph's views about other aspects in the world, but about the people who are involved in this case at making findings and determinations in this case. And the second one also that he believes me to be interacting with people with some rapper who I never know or never even don't know what that is. But that also concerns me that basically Mr. Randolph's delusions do extend to his counsel and what we are doing as his counsel. Those two aspects were new to me today, and I wanted to add those in what concerns us. Thank you.
Before I get to you, Ms. McDuffie, I guess I was surprised to hear the statement about him believing that I know his mother and somehow I'm communicating with his mother. I don't know who his mother is, first of all. So that is not the case. I'll just make a record of that since it has somehow become an issue. But before I go to you, Ms. McDuffie, I wanted to ask you something. The piece of that, though, is that in spite of that, even if Mr. Randolph sits there today believing that I know his mother and his mother's in my ear, or that you are somehow communicating with the rapper, which I don't know if you've ever had that conversation with him or not. It sounds like you didn't know about that until today. That even if he believes those things, he's able to compartmentalize them, meaning that he can set them aside and say, despite all that, I want to work with my attorney to get to an end result here. That is what he testified to today. I mean, technically, he could believe anything he wants to believe, whether they're delusional or not. The question really is, can he assist you? And what you said to me today regarding this, which is interesting too, because you're not technically a witness, is that you have concerns about when he calls you, making him maybe unable to make decisions at certain points in time. But it doesn't sound like you're saying that that's a consistent thing and that he's always not able to assist you. So the ultimate thing is whether eventually he can assist in his defense, not whether at some moment he may be having issues, but ultimately whether he can assist.
That is correct. Yes, I am not making the claim or representation that Mr. Randolph is what I call quote unquote incompetent all the time. No, that is not so. We have had good coherent conversations where I think there's nothing off with it. But those are the exceptions.
Well, as he sits there today, seems to be, I mean, I haven't talked to him and you haven't either, but he put his appearance on the record like he understood what was happening. He's not doing a host of things that people who have real challenges do when they come online. People do a lot of odd things. He seems to be behaving in a very normal manner today. So I don't know, you can put on the record whatever you want to put on about that, but that is obviously one of the concerns that I have.
Yes, I do have an observation in response to believe just that. There is going to be a point in time when we have to decide, make a major decision about the case, whether to take a plea or whether to go to trial, or I think those would be the major decisions. And when it comes to making that decision, that very moment, I don't know that I'm going to be confident in his ability to make that decision at the time, because of that's my concern.
All right, thank you.
Yeah.
Ms. McDuffie?
So I believe that there's a lot of things in this hearing that a lot of us know just from practicing and being somewhat familiar with this process. And then we have the testimony today. In addition to that, as the court mentioned, we're not witnesses, so I'm trying not to testify. But at the same time, we also have, I think each of us may have observations of Mr. Randolph from different points in time that are relevant here. I think we heard today and know that a person having a diagnosis of a mental illness does not make them in and of itself incompetent to stand trial. As everyone's aware, individuals can have multiple diagnoses who may or may not be adhering to a course of medication or treatment and can be found competent. I think that it presents a unsolvable problem that defense raises, which is that he doesn't know from one moment to the next whether Mr. Randolph is competent or not, because had the findings from this report stated that Mr. Randolph was not competent to stand trial, that I don't know that that would have been challenged for the same reason. I'm not accusing counsel of anything. I'm just saying that the difficulty from one moment to the next and from things going back and forth presents the same problem in reverse. So it's not a situation where I don't think that the court can just sort of independently find him to be incompetent because that his appearance may change. Mr. Parker, I think, made it very clear what the purpose of the evaluation really is, and it's for that point in time. Obviously, we don't do criminal responsibility for misdemeanor, so I can appreciate that he did not get the diagnosis of schizophrenia until after he was referred, but we heard that that would not have made a difference because of the way he presented. The report is, I think, gives a very thorough review of just how much understanding and clarity Mr. Randolph has about this case, about the legal process, about his options, about his choices. And I have to say, just anecdotally, it's one of the most well-appearing defendants that I've ever read about in one of these reports. I am not saying that with any sort of, attempt to put myself in the shoes of someone qualified to make these diagnoses, but it made an impression on me about just how together Mr. Randolph had it during this evaluation. I do not doubt counsel's report that sometimes it's different. But I do have to say, the concern about competency was raised with some timing that raised an alarm for me. Again, not doubting counsel's ability to make that observation at all. That particular day, and counsel and I discussed this, it appeared to come out of the blue. And it was based on behavior Mr. Randolph exhibited the same morning he was facing a very high likelihood of having his bond revoked. And that followed me observing behavior from Mr. Randolph that clearly suggested that he was at least aware of his ability to be manipulative. I won't say that he was at that exact moment, but he inquired about it on the record during his arraignment. If nothing else, that gives me, I think, maybe assurance is not the word I'm looking for, that Mr. Randolph is aware of where he is in this space, in this process, and of the decisions that he has made and can make, and how it's going to affect him in this process, even to the extent of him at that arraignment being informed about what he could and could not do and trying to figure out how to get around it out loud. So I accept this report as written. I believe that Mr. Randolph is competent to stand trial, and I think that Mr. Parker's testimony supports the report that we have here. I do understand Mr. Dowse's concerns that his situation seems to fluctuate, but I don't think it's in a way that ultimately affects his competency to stand trial in this case.
Thank you. Having heard testimony from Mr. Parker today and having reviewed this report, I find that I will accept the report and Mr. Randolph's statements around it, specifically the part that I think filled in the holes that Mr. Dowse had mentioned earlier in this process, in this hearing today. The whole being, did he have the information? If he had had the information regarding this diagnosis, would it have changed his opinion? And he said it would not have. And the reason for that is, although Mr. Randolph may be suffering from schizophrenia, the reality is that the delusions that he suffers from that might affect this case, he's able to compartmentalize and decide that he wants to work with Mr. Dowse to actually handle this case and resolve it in whatever way he sees fit to resolve it. The thing about competency is this, though. Mr. Randolph was competent at the time that this report was made. I don't know what Mr. Randolph's state is now, other than what I observe here on the screen, and he appears to be very compliant with what we would see as normalcy in a Zoom environment, and he's behaving appropriately and giving me the impression that he's okay. However, I don't know what his conversation would be like with Mr. Dowse. And so those types of situations they fluctuate. Something that Ms. McDuffie said earlier, which was if he had been found incompetent, then it could work in the reverse. In fact, it would work in the reverse. We would then try to determine whether we could make him competent or not. The reality is he may be competent right now, and I'm entering a finding of competency regarding this, but that does not say that if at a later point in time he's not able to assist his attorney, then another referral wouldn't be made. That could happen also. I understand and I accept what you're saying, Mr. Dowse, about your realities with him, but the situation is this. Unless that particular behavior is affecting him at a moment in time where that major decision you're making is on the table at that moment, it really doesn't mean that he can't assist you. It just means he can't assist you at that moment. And maybe you need to have a conversation later, unless there becomes a very pressing moment in which it evidences itself and there's nothing that you can do about that. So it's a very complicated situation that you find yourself in. But at this moment, he is deemed competent and we can move forward. That is my finding. It is notable that with respect to competency and the prongs, the two that we have to look at, whether he has whether he's capable of understanding the nature and the object of the proceedings against him. Mr. Parker's report fully outlined in quotes the things that Mr. Randolph said that clearly and fully outlined that he fully understands the nature of the proceedings. The only question was and is whether or not he could assist his attorney, because he seems to understand everything. It's just whether he can assist his counsel. And your issue that you raised about his behavior and the fluctuation of that is how I come to the conclusion that he's competent now at the time of this finding, and I find that he's competent. But if at some point in time you have additional issues, of course, that can be re-raised as an issue before this court.
Thank you, and I take it just so. I agree it's a complicated issue and situation, and we'll go from here.
All right. So
as far as an order, is that would you want that to come from us or from Ms. McDuffie?
From you, please prepare the order.
I will do that.
And then I know at one point we were having some bond issues, and I think there's a bond hearing that is still outstanding until we dealt with this competency issue. Has Mr. Randolph been participating in his bond conditions appropriately at this point? He's shaking his head up and down, sort of like a yes.
We did receive an updated report from Community Corrections. I believe Mr. Randolph does a continued testing. He does show up for testing. He misses on occasion, and he continues to test positive. I'm sorry, I don't have the report at my fingertips, but I can pull it up in short order. I believe what we earlier considered doing once the competency issue was determined, that we would then schedule a very soon pre-trial bond violation hearing at which to address these items. That is my understanding.
And from the people, I don't mind addressing it now because I made a record at earlier hearings. I alluded to it during this one, and I can lay it out again now if necessary. Where the roots of that are from, but I looked in JIS and it appears that Mr. Randolph was granted permission to use medical marijuana.
He was
at some point, so that would resolve I don't know if that It doesn't necessarily change the fact that it was being consumed before and the circumstances that I was referring to about him trying to figure out how to get a medical diagnosis. At least that's the way it appeared in that particular hearing. Are really what concerned me. But the bottom line is that the court has granted permission now. So if we can address the previous status now, if the court would like, or if we want to schedule a different time, that's fine too.
Right, we can do it at a different time. I mean,
Thank you.
like you said, he has been deemed able to use it based on the letter of necessity that I received. But I don't believe that. I mean, pretty much every defendant that is using is trying to figure out a way to get that medical necessity letter. So that is not unusual. Having said all that, I guess we need to look at a date for an actual pretrial. And if any additional issues want to be brought up regarding that bond violation, you can do that at that time, Ms. McDuffie. I don't know if we want to. Are you still requesting a hearing regarding that, or I think we're kind of past that point?
Yeah, Your Honor, it was the bottom line of that. Again, it was just my concern of the initial arraignment, the comments that he made, the fact that he continued to test, did not, I don't want to say refuse, but did not get the confirmations that he was ordered to multiple times. And then we just ended up with him coming up with the documentation. That, as far as I'm concerned, that I think is addressed even within the hearing we just had, because that showed me some awareness of his behavior and conduct. So I don't need to go any further with that.
All right. As far as pretrials are concerned, unfortunately, my days are pretty full right now. We're looking at this May 16th or May 23rd. I have them here pretty much for hearings for the next pretrial dates. Mr. Dowse, what does that look like for you and your client's schedule?
On my end, either one of those is a good date. The 23rd is somewhat better because I have a trial scheduled in the week of May 14, 15. So ideally, I wouldn't have another one right after. But I could do either the May 16 or May 23rd. Either one is fine. And in any case, we will use the time with Ms. McDuffie to make sense of the case.
May 23rd, 2024 at 9 a.m. Bond is continued.
Thank you. Is that still by Zoom or are we in person? Zoom.
Yes.
Very good. Thank you. I will turn out that order and submit it to court. Probably not before end of day, but I will see to do it today.
Thank you. Thank you very much.
Thank you.